the importance of being able to access basic systems repair. I mean, that's really critical. It's something that we're especially concerned about, and a number of municipalities have it. We're actually looking at legislation now to scale that up. In Philly, it's helped 5,000 homeowners make essential home repairs for free, essentially between 2018 and 2020. And then you mentioned that the decrease in crime, according to the study that that has actually made the rounds a little bit. The other part of it is like people need to make those repairs in order to weatherize their homes, which we're just a few days past a flood, right? And
floods, tornadoes.
And this is why we need basic systems repair. We need weatherization. We need to be, that also has immediate benefits in terms of utility bills, homes that are more comfortable. So but in order to qualify, as you mentioned, your home can't have a tangled title. And I think this is where our work really, really intersects. I did want to ask one piece of legislation that has been adopted in other states is called the Uniform Partition of Heirs Property Act, the UPHPA. Mm-hmm. And it's not been adopted in Pennsylvania. And I'm curious how much you come across this, that when someone dies, their property gets distributed to their heirs. And then when those heirs die, the property is passed to their heirs. And then this opens up the possibility of a tangled title. So if one of the heirs decides to sell the property, they can force a court-ordered sale. And as a result, family homes can be lost to developers who are eager to kind of just take the properties and nab them at court-ordered sales for less than fair market value. I know this is an issue in many rural parts of the state, and so this is an act that other states have adopted to kind of by essentially providing for other non-selling heirs a right of first refusal and requiring the selling heir to sell their interest to the other heirs. I don't know if that's come up in your work, Attorney Wilson and Register Gordon.
Well, that's very interesting because some version of that law has been used, particularly down south, a lot to divest people of color from their land and their property. Yeah, so it's a really big problem. And here it is a problem because whenever you want to move forward, you have to get all of the heirs' names and notice and all of those sorts of things. And because it's required, we have to require it as well. I think that could be helpful as long as we are making sure that we exact the balance, that those heirs are sort of notified that before they're losing assets, and then, and making it easy to make this happen. Maybe something that allows you to one person to sell, but to escrow the monies until we, maybe do a more detailed search, but something that doesn't, allow people to be disinherited because it gets complicated. We don't want to exchange one problem for another, but I think that's going along the right route. Let's find out what we can do when there's all of these heirs that need to be notified in order to make one move, which is another reason why a legitimate heir may look at that and say, I can't afford to do that. Whereas a developer might come in and say, the pot of gold at the end is good enough for me to try that. So that's something that we do experience a lot at the Register of Wills. And I like the idea of that law in terms of where it's going, as long as it enacts the proper balance between those parties.
Got it. Yeah.